Just not that loud.
Okay, welcome everyone. It's 1 o'clock, so we'll go ahead and get started. This is the pre-hearing conference for Denver Brick Company's Golden Mine. It's a 110C to 112C permit conversion application number 1. Division permit number M1976-007-UG. My name is Jason Music. I'm a senior environmental protection specialist with the division. I'll be serving as the pre-hearing conference officer representing the Mineland Reclamation Board for this issue. So real quick, we're just going to go around this room. I think you guys can see on your screen, we have a conference room full of a few folks. So we're going to go around this room for introductions. At that point, we'll turn it over to the representatives of the applicant for introductions. So Charles, you want to go?
So I'm Chuck Hoyman with the Attorney General's Office. I'm counsel to the board.
Russ Beans, I'm the Minerals Program Director.
Jeff Fugate, also with the Attorney General's Office. I'm representing the division.
Good afternoon. My name is Michael Cunningham. I'm a senior environmental protection specialist and was involved in the review of this application.
And my name is Eric Scott. I am the environmental protection specialist who reviewed the application for this conversion.
Okay, thanks. For the folks representing the applicant, could you go through and give us some introductions?
Hi, my name is Joe Middleton. I'm an attorney representing Denver Brick, or the applicant. I believe I'm the only participant for the applicant today.
I'm here.
Oh,
I'm here.
Pardon me.
I'm Angela Bellantoni. I worked with Golden Mine.
Thanks, Angela. Thanks, Joe. Can we see how many folks we have, Michael, real quick? 19. We will, once we get to the, start getting into the identified parties, we're going to go through and kind of identify the folks that are on the call in a couple of different ways. So we'll get to the introductions and identifying parties here in just a second. As you know, the purpose for this pre-hearing conference is to describe and provide an overview of this conversion application and the process that it went through with division staff. We want to identify all parties to this action. We want to explain the rights and responsibilities of the parties. We want to try to identify and discuss and potentially resolve any issues to the extent possible. And finally, we want to establish the Mineland Reclamation Board hearing process. That process includes proposal of a list of jurisdictional items that the board will hear. We want to try to attempt to simplify the issues to the extent possible we can. And we also want to establish timeframes and the order in which the Mineland Reclamation Board hearing will proceed. So at the conclusion of this pre-hearing conference, there will be a draft order that goes to the board with our recommendations. That order is just that, it's a draft. The board may or may not adopt what we decide here today. They have authority to revise it, modify it, not adopt it at all, however they see fit. But for the most part, what we agree upon here today will be presented to the board and for their adoption. The draft pre-hearing order will identify 4 specific issues. That's going to be the hearing process that we agree upon. It's going to identify all the parties involved. It's going to identify the issues to be heard. And finally, it's going to be identifying the proposed schedule in terms of timing and order that we agree upon here today. So that said, that's kind of why we're here, pre-hearing conference. Are there any questions in the process before I move forward to individual parties and identification of those parties?
Yes, one question if I could.
Sure.
We're asking about process questions and some topics as well. We do have 2 expert witnesses. Are they allowed at this time to ask questions as well about stuff that they might bring up, or does it have to come from the party only?
Yeah, it's you can answer that.
Sorry, so, I mean, you'll see as we go through this, but as Jason pointed out, really what we're doing is identifying kind of what the division is going to recommend to the board as the jurisdictional issues.
Right.
And then work on allocation of time. I mean, to the extent that there are disagreements over, if parties disagree with the division's call on what's jurisdictional or not, as Jason pointed out, when the pre-hearing order is presented to the board, that would be the time for an argument that, no, we really think this issue is jurisdictional and the board should hear it. And that'd be the time to kind of present that argument. If there's a little bit of that today, that's fine too, but it's just really not a forum to really kind of slug it out over what is and what isn't jurisdictional.
No, I must have misunderstood. I thought you guys had just said one of the points is to bring up the items that we'll talk about. And I just want to see if I missed something or someone in our group missed something, if we could just have that covered by one of our expert witnesses, if they're allowed to talk about that kind of thing or not. I just don't know how this works.
Do you mean at the hearing?
No, just right now that you guys had just mentioned that one of the things we're going to talk about in this process was certain items to be discussed on the 20th. And if I missed a specific checkpoint of what we were thinking, would they be allowed to correct me?
Sure.
Let's just move on. Sorry.
We'll discuss the items, the issues that the objectors raised. We'll discuss those, and we'll get to that point, and we'll find out if those are still issues that are unresolved, or if they have been resolved to the objector's satisfaction based on the division rationale. So we'll get to that once we get all that down. So are there any other questions about process? Just why we're here kind of thing, pre-hearing conference, questions about what we do, why we're doing it? Okay, so moving on. At this point, we're going to get into the party status and the identification of parties. So how we're going to do this is generally we'll have to find out who all is on this call. So we have 3 criteria basically that's going to identify a party. And of course, if you've submitted a timely objection within the 20 calendar days of the date of the newspaper publication, then that's your first step to being identified as a party. We had a number of parties identified based on the 2 public notices that ran. I believe the first public notice ran, I think there was 27. Second one was 158 for a total of 185. I don't see 185 people on this call. So that leads me into the second requirement, which is a party must attend this pre-hearing conference in order to be identified as a party. So one caveat to that is if you're not here at the pre-hearing conference, you can be represented by proxy. So right now at this point, I want to just ask, is there anybody represented or any proxy representing any identified party that submitted a timely objection? Do we have any proxies on this call?
No, nobody told us that was a thing, but I can't confirm that we are representing any proxies, but it'd be nice to know that.
It was in the writing. It was in the rules.
Okay, my bad.
No, that's okay. That's okay. So no official proxies, notarized proxies submitted? Okay. And then the third criteria, of course, is the identified party must attend the public hearing for the actual Mineland Reclamation Board hearing. So those are basically your 3 criteria. Your first one, of course, is submitting that timely objection. Second one is to be in this pre-hearing conference or represented by proxy. And the third, of course, is to attend the public hearing. By being identified as a party, of course, you have certain rights and responsibilities. At the board hearing, anybody identified as a party can present evidence. They can call witnesses. They can cross-examine other parties' witnesses. The party also may be represented by an attorney at the board hearing. And the party has a right to litigation or to be subject to litigation in district court on matters surrounding this application's review and the board's decision. Finally, only identified parties to a hearing can seek judicial review of the board's decision. And finally, if any party wishes to withdraw as a party, you must do so in writing prior to the commencement of the or on the record of the board hearing. And even if you choose not to be a party or withdraw your party status, you may still address the board on matters of concern. However, you will not be entitled the rights of a party. So that said, are there any questions on identified party status? So what we're going to do is we're going to use the record of this Zoom call as identification of individuals that have attended this pre-hearing conference. But I also want to ask, just as a check, is if you could please in the chat, just go into the chat on the Zoom call and just state your name. Just open the chat up and just write your name. That's it, nothing else. And then we will memorialize that chat, print it out, and then I'll have a record of everyone who was on this call who will be identified as a party. Okay, any other questions on parties and your status as a party to this action? No questions. Okay, so we'll move on to motions and materials for the actual hearing. So I'm going to give a couple of dates regarding motions. Parties wishing to file motions, those motions must be received by the board administrator no later than 2 working days following this pre-hearing conference. So that said, if you wish to file a motion, you must do so no later than 5 p.m. on July 11th, 2022. That's the date to file motions. Any responses to motions filed must be received by the board administrator no later than 3 working days before the board hearing. So that date is no later than 5 p.m. on July 15th, 2022. So those 2 dates again, any motions must be submitted no later than 5 p.m. on July 11th. And any response to motions submitted must be received no later than 5 p.m. on July 15th. Question? Go ahead, Mr. Wyman. You have to unmute yourself there.
Thank you.
Go ahead.
Are any motions that may be submitted within the time frame, are they public record? In other words, if I wanted to respond, I would have to read it first. So right. Are they public records, my question?
Well, that's a good question, Mr. Wyman, because any parties who file motions must serve those motions to all other parties and to the division.
Understood.
Okay.
Okay, that answers it. The onus is on the submitter.
Any other questions on motions? Dates? Everybody got those dates?
Is there a link or something, or will something be provided in order to serve the motions on all other parties?
Yeah, are we doing the link, or are we going Cami and then Cami's doing the link? The link.
We'll post it.
Okay.
To the same place the witness and exhibit list will go. That
Sure.
way everybody has access.
Okay. We'll post that link, and it'll be the same link where all the exhibit and witness lists will go. So you'll be able to drop those motions in there.
It's an email address.
Yeah.
So if I could just clarify, we don't need to email each individual party. We will simply file our motions by posting on the link that you guys will provide.
That's right.
Thank you.
Yep.
Is there, something's posted, does everybody who has the folder get notice? No. Okay.
That's a good, so you'll, so yeah, you'll have to check that link and what's in it. It'll be a Google link. You'll have to check and see what, because you're not going to get notified of it, of anything that goes in there.
Yeah, so just make sure you're checking. I mean, Jason went over the deadlines. So, you know, we'll make sure that things get put in. If anything's filed, they get put into the Google folder. Make sure you're looking. So you've got notice. Okay.
Thank you.
Okay, and that leads us to the materials for the hearing. We kind of discussed them a little bit, but we'll need any list of potential witnesses and list of exhibits as well. So those will also go into that link. If you haven't already submitted them, we'll need those submitted. I think a lot of them have been submitted by email already.
We received some, yes.
And so those will be going into that same folder. So everybody will have access to the witness and exhibit lists for all parties.
We want to see if you.
Can you guys clarify what that address is for the parties here? Just so they know they're sending it the right email address.
Sure. It's on that one. I won't be spelling out the link, but the link is in the
Cammy's email.
Oh, Cammy's email. Oh, Cammy's email. Yeah. So Cammy's email is, if you guys want to write this down, it's CAMILLE.MOJAR@state.co.us. And Michael Cunningham will put it in the chat. So you can copy and paste that.
So it was in the notice letter. It was in the notice letter.
It was in the notice letter. Yeah, it was in the notice for this pre-hearing conference.
And can I ask one other point of clarification? Can you explain the deadline for submission of witness lists and exhibits?
Sure. Yeah. So the deadline for potential witnesses, the list of potential witnesses and list of exhibits should already be in there. That's the deadline. But if you can't get them in, if they're not already in right now, we'll need those by, Russ, 5 p.m.?
5 p.m.
5 p.m. today.
Thanks.
You bet.
One question, we had someone new on jump on the line. I don't know if they heard the thing that they have to put their name in the chat, but someone by the last name of Wheeler. Okay. I think we all have to put our name in the chat. Just want to bring that up.
Thanks. Yeah, if you jumped on late, please just put your first and last name in the chat, just for record of who's on this call. Thank you. Okay, next up, what we're going to do is Eric is going to provide a summary of the permitting proposal and the review process that the division did. Once we do that, then we will, well, I'll start running into the summary of the outstanding issues that we have. So, so Eric's going to share his screen and.
All right, can everyone see the slides that are up on the screen?
Yes.
Excellent. So if you attended the informal hearing in February, many of these will look very familiar, but we do have a couple of updates we want to point out. Just for starters, here is our site location. This is an aerial overview of the proposed permit area plus the surrounding areas. I'm guessing you're probably all familiar with the area we're talking about at this point. You can see Highway 93 there running through the center of the photo, north to south. This is a photo or a drawing from the permit application, which shows the proposed permit boundary in addition to the 200-foot buffer affected area around the permit boundary itself. So that inner red line is the proposed permit boundary. the 200-foot outer red line is sort of a buffer for us to identify adjacent property owners and structures. Now, this is the review timeline for this application. You can see we've got a pretty extensive timeline going on here at this point. But the permit was originally issued in October of 1977. And the new items we'll point out here, after the February 25th informal public meeting, we sent a third adequacy review to the applicant. We also provided the notice of the pre-hearing conference and formal board hearing on June 16th. On June 30th, we issued the recommendation and rationale letters, and those were sent to all parties via the email address that they provided us. And today, on July 7th, we're holding the pre-hearing conference. And in a couple of weeks, July 2021, will be the formal board hearing for this application. Now, the application under consideration is to expand the existing permit from 9.9 to 70.15 acres altogether, although only about 46.7 acres of that would be impacted by mining activity. The rest is unimpacted buffer areas within the permit itself. The primary commodity is clay for use in brick making. The State of Colorado State Land Board is the landowner for the entirety of this permit area. And the type of mining is surface excavation, and it consists primarily of just earth moving. There will be no processing on site other than the screening of oversized material with a grizzly. And the post-mining land use for the site is rangeland and open space. And this is the proposed mining plan map from the application itself. And you can see the inner and outer red lines that we looked at before, sort of overlaying over an aerial photograph. You can see the mouse here. The black line that I'm tracing is the area within the permit where there's proposed mining activity to take place. And this is an overview, cross-section topo of the proposed reclamation. And this map's not terribly intuitive, but it does show the, I guess, open space and rangeland reclamation area for the mined area. These cross sections are a little more illustrative. They've got the current topography, and this is shown on sort of an east to west cross section here, or west to east, I guess I should say. The ridge coming down, and there's the current topography. This would be the edge of the permit area. And on reclamation, you can see how we've removed some material here, has been mined out, but it is still a flatter area sloping up into the existing ridge line. There's some shrubs and grasses here, and then it tapers back out into the adjacent property, which is owned by Jefferson County. And this is a bit of a real life illustration of kind of what we're looking at here. This is standing within the current permit area looking immediately north. And this was a previously permitted and mined area that I've outlined in green that has been reclaimed and released. And the idea is to make this new expanded permit area resemble and blend into this existing reclamation to the north. This is a little bit of a history of the review process. We received 185 timely electronically submitted objections. We received comments from 3 agencies, including History Colorado, State Engineer's Office, and the State Land Board. And we did receive 1 untimely comment from Colorado Parks and Wildlife early June. And we reviewed all those comment and objection letters as part of our review process. And we feel that the jurisdictional concerns raised by the objecting parties have been addressed sufficiently through the division's adequacy process. And that process is now complete. The recommendation and rationale letters were issued on June 30th. And as before, and since the beginning of this application, all the permit documents can be viewed through the website at http://drmscolorado.gov. And this is a little bit of a visual tutorial, I guess, as to how to access those documents. What we're looking at here is a screenshot of the DRMS homepage. And you can see where the yellow arrow is pointing to applications under review. And you can hit that link and it will take you to permitting actions currently under review. And once again, if you look to where the yellow arrow is pointing, there is a link to information specific to the Golden Mine application. You can click on that link and that will take you to the important dates, document links, public document review, and the public comment periods, which are both closed at this point. But this is where you'll access the documents associated with this permit. You can also access this material through the online image documents link. And if you use the hint here to enter the permit number in this field shown by the yellow arrow and hit enter, it'll bring up all of this material, and there's pages of it. The permit goes back to 1977. But then what you probably want to do is sort on the doc date header at the top of the page, and you can sort either in ascending or descending order, and that will make the more recent materials much, much easier to find. And I think that's where we are for now. Stop sharing.
Can we ask questions?
Sure.
I have one question. Could Mr. Scott give us an idea what area is not affected by mining? You indicated that in your presentation. I'm not sure what area you're referring to.
Areas outside of that black line that were on that map are not specifically slated to be mined. There may be some smaller impacts as material is moved from point to point, but the areas in black on that map are the currently specified, down a couple, mining areas.
Bear with us just one second. We'll pull that up just to make sure we're pointing out that. So again, the black line that is being traced here as the area within the permit boundary that'll be affected. The
stockpile area there.
Yeah, this is the stockpile area. The red line denotes the actual overall permit boundary.
The inner red line.
Pardon me, the inner red line. So the area between those will end up being a buffer and will be unaffected by the mining operation. And again, these maps can be viewed through the online Laserfish link that Eric just pointed out. If you wanted to pull them up and view them in greater detail, that you can download them and save them as PDF files. Did that answer your question?
I just have one follow-up. Why is it that the area shown in black is not extended to the actual permit line? Why did they decide to choose a smaller area to mine? What's the basis for that?
Well, I don't know that we're in a position to answer that specific question. Perhaps the applicant would like to address that, but I will just say that the permit boundary is the overall boundary for all of our mine sites. Within the permitted area, you can designate a smaller area to be affected. The affected area is what we develop a mine and reclamation plan for, and that is also how we take a look and establish the financial warranty that must be posted by the applicant for all areas that will be affected. So sometimes on our applications, we have a subset of affected area that's smaller than the overall permit boundary. There's a number of different reasons that applicants choose to do that. But I think that might be better addressed by the applicant if they would like to respond.
Well, I'm sorry. Yeah. Is the Dakota hogback to be destroyed within that black line area?
The areas within the black mine are slated to be mined. And just to be clear, at the conclusion of mining and reclamation of this site, the hogback will still be there. The hogback is not coming down.
I'm glad to address Mr. O'Brien's question if that's helpful. In essence, really, we're after the clay resources at the site. That's what the applicant is interested in mining. And those resources don't extend to the entire permit boundary, even though the permit boundary is more or less extensive or coextensive with the lease boundary with the SLB. But the clay resources that will be mined are not coextensive with the entire permit boundary. And so we will focus only on those areas where the resources actually exist.
Thank you.
Okay, Mr. Wayman, questions?
Yeah, just one point of clarification. In Mr. Scott's overview, his first or second slide, or somewhere at the beginning, indicated the application was submitted to DRMS in September. My understanding, it was submitted initially incomplete in August, which is August or September.
That is true. There was some incompleteness issues that were resolved, and the application was filed for review as a complete application on September 8th.
Well, it was complete, but it was submitted in August. Seems to me that slide should reflect the submission date. Just a small technicality that I noticed.
Noted. The review period and all the associated timeframes do not start until the application is actually called complete and filed.
That's not how I read it, but so be it. I'll double check that.
Thank you. Any other questions for staff before we move on to the outstanding issues? Okay. Before we get into the a summary of the outstanding issues, I just wanted to confirm and make sure that everybody received the division's rationale and that the issues identified were categorized and the division addressed the issues that were submitted in the rationale. So with that, we will move on. If you did receive the rationale, you'll note that the division categorized the outstanding issues or objections into 8 categories. So what we'll do at this point is I'm going to go through each one of those categories. And I want to make sure that based on the division's rationale and the information that you know to date, that those issues are still issues, that those issues have not been resolved to the satisfaction of the individuals who objected to those. If they have been resolved, if you've gone through the rationale and there's certain items that are categorized in here that you believe have been resolved to your satisfaction, then we can omit those and the board will not hear those. If there's still outstanding issues, those are the issues that we're going to decide here today that the board will hear in a couple of weeks. So with that, we'll start with the first category. The first category was conflict with existing approved land use or county zoning. And there were a number of objections received that stated in some form that the operation conflicts with existing Jefferson County land use and zoning requirements, and therefore the permit expansion should be denied. The division addressed those comments in their rationale. So I just want to ensure that that is still an issue at this point. Anyone who had that objection, feel free to speak up. Mr. Wyman.
I think the land use zone versus L&E is in fact still an issue.
Okay, thank you. The second issue category, the second category is hydrologic balance issues. The division put those in 2 subcategories. One was groundwater quantity and quality concerns. Second was surface water quantity concerns. There were a number of objections on both of those. The objections cited concerns with potential adverse impacts to the quantity and quality of surrounding groundwater and or drinking water wells due to the proposed operation, and cited concerns with the potential adverse impact to the quality of nearby surface water or non-specific water quality or watershed concerns due to the proposed mining operation. Are those still concerns, or have they been resolved to the satisfaction based on the division's rationale?
Still concerns.
Okay. Third category, wildlife sensitive and environmental or floodplain issues. We received some objections, cited general or unspecified concerns with potential adverse impacts to wildlife, wildlife habitat, sensitive environments, wetlands, and potential floodplain area issues as a cause for objecting to the proposed conversion application. Have those issues been resolved based on the division's rationale, or those remain as issues?
Still concerns.
Okay. Fourth category was offsite damage or blasting concerns. We received a few objections that raised concerns related to blasting or potential damage to offsite structures as a result of the proposed blasting activity at the site. Division addressed those in their rationale, so I want to make sure that those are still concerns as of this date.
Still concerns to the safety of the community.
Okay. Fifth category, the division received a few objections citing mine plan adequacy. Those were cited for general or unspecified concerns with the inadequacy of the mining plan provided with the application. Based on the division's rationale, we feel that those issues have been resolved, or will those remain issues that the board will hear?
Still concerns.
Sixth category, looks like we received approximately 6 objections citing general or unspecified concerns that the reclamation plan provided with the application was inappropriate or inadequate. Based on the division's rationale, has that item been resolved, or is it still an issue?
Still a concern.
Okay. Item number 7, it was a category that defined completeness and accuracy of provided application materials. The objection, this is one objection, the objection received cited concerns of completeness and accuracy of the conversion application materials. So based on the division's rationale, has that objection been resolved or not?
Still a concern.
Still a concern, okay. And finally, we received 2 objections on category 8, which was reclamation bond adequacy. Objections received cited that the reclamation bond amount specified in the estimate provided in the application was inadequate. Based on the division's rationale, has that item been resolved?
Question.
Sure.
Is it deemed to be inadequate by the objections based on the possible disturbance of groundwater from that 2009 letter?
It's the, it was basically saying the estimate that was provided by the division of $288,540 was inadequate for the review of the application, for all items associated with the application.
Anyone?
Just a clarification.
Sure.
I assume that's in today's dollars, since the reclamation plan is 30, 40 years out.
Sure.
Was that adjusted for inflation ultimately?
Sure. That's the amount that's estimated today. But be aware that the division, at its discretion or throughout regular inspection and enforcement monitor inspections, that those costs will be updated accordingly. And the division, of course, updates their costs that they use for cost estimates yearly, starting July 1. So is that, is the category of reclamation bond adequacy an issue, or do you believe it's resolved, or do you have more questions?
If I could speak for some of the people on this call, I don't think we've discussed that, nor do I think we've identified it as an issue.
Okay.
That being the case, I don't have a lot of heartburn letting that one be
Okay.
removed. But I don't speak for everyone. But
anyone else? No issues?
I agree with Terry.
Okay. And we will mark item 8 or category 8 as resolved in this pre-hearing conference, and it's an item that the board will not address. So what that leaves us with, items that the board will hear are items 1 through 7. Those items based on objections have not been resolved according to the division's rationale. So those are the items that the board will hear.
Could I just ask for some clarification on those items?
Sure.
Sure. On zoning in particular, you know, I take it the board would agree and the division would agree that correct zoning or rezoning of the site is not a jurisdictional concern. And so I think it would be helpful to have a more precise sort of understanding of the objector's expectations or comments, or, you know, what it is that that we're trying to, that will be heard at the hearing with respect to zoning.
Sure. Well, I think the division could probably address why they believed that the, and it may fall under post-mining land use criteria, but that they can discuss why they believe this category fell into the line of a jurisdictional issue.
If I'll handle that initially. Jeff Fugate, again, attorney for the division. This was included as part of the rationale. It was raised by a handful of objectors. My understanding of how it was framed in the objections, and I'll defer to the objectors to better clarify what it is they're seeking or why this was raised as an issue, was that this application could not be considered or approved because of a potential conflict with Jefferson County zoning and regulations. As briefly discussed in the rationale, the division disagrees with that position. This application is not unusual in that it, you know, the applicant does not have all of the required local permitting in hand when they submitted this application, just as they don't have other required permits. What's required under our active rules is that they indicate in their exhibits in the application which federal, state, and local permits they are required to obtain before they can commence the mining operation. And that's the standard that the division applies, that the board typically follows, is so long as they have all of the required permits, then they can commence the mining operation. But until they have those permits, they cannot move forward with the activity. It's not unusual for applicants to begin with the state process because of the level of review conducted by the division. And that's where we find ourselves here is, again, the application references the permits that are required and the process that you all will have to go through with the county. That being said, I'm not sure exactly what issues remain for the objectors or how they're going to frame this or present it to the board. So I'd reach out to the objectors on the call today if maybe we're misunderstanding the objection or if there's a different issue that you're looking to be resolved through this hearing.
Jeff, if I may ask a question, because you brought something up about federal, local, and state permitting and laws. When we read, is it 34, 32, 32.5, 115, 4D, we would like a little bit of clarity on that because it doesn't say that you'll obtain, I don't believe. Could we check that real quick? I just want to see where we're at on that.
I also jump in.
Peter, you're first.
So I think Mike has the right law, though I would cite the provision immediately preceding it, 34, 32, 115C, or 4C has two provisions, capital I and or Roman numeral 1 and Roman numeral 2. In Roman numeral 1, it basically requires that the board not approve, or rather that the applicant prove that the mine is not in conflict with any current state laws. Zoning itself is a state law. There's Supreme Court precedent, which I attached in my exhibits, that explains that basically zoning is a delegation of authority from the state down to local governments to determine their own land use. You, as far as I can tell, actually, and this is something I disagree with the board's rationale too, must change the zoning prior to approving this permit application. This is distinguishable from permits themselves. For example, as I'm sure Mr. Middleton knows, the mine must get a site plan approved. That's a permit in and of itself. That approval process could occur after DRMS or the board approved this. I suppose it's really a change rather than granting a whole new permit. I don't see any adequate addressing of the distinction between state laws relative to licenses and permits, and that's what I hope to bring up in front of the board. And I have several exhibits that I've sent to Cami yesterday with respect to the fact that this has already been zoned something, the fact that zoning is indeed an exercise of state law, and the relevant provision that I think the board, that the applicant has failed to demonstrate compliance with state law.
Well, let me just say, we have every intention of zoning the site appropriately for the activities that we anticipate. Certainly we're not going to move forward with any activity that would violate state law. We don't dispute the fact that zoning is a state law of any kind. It's just, I think there's some disagreement about the order of operations. And our view is that, it's kind of a chicken and egg situation. In this case, we've sought the DRMS permitting before we have completed the zoning process, but we remain engaged with the Jefferson County folks, and we will certainly continue that process and obtain proper zoning before we commence operations.
So when you say you remain engaged with the Jefferson County folks, I spoke to one of the zone and planning board members literally yesterday. They don't have an application for you to rezone that parcel yet. So I'm not sure how engaged I would call that, but regardless of that, there is existing state law on the books that actually spells out the order of operations. The board, you have to demonstrate to the board that you are not going to violate any state law. The parcel is currently zoned agricultural. Agricultural does not permit mining. Therefore, you need a rezone before the board can grant your application. I'm going to maintain this position in front of the board. I don't understand how you can possibly get around what 4C Roman numeral 1 says.
Yeah, I think we just have a disagreement as to how to interpret that requirement. And so, we'll welcome your arguments and, listen attentively. But again, we will pursue whatever zoning is necessary before we commence mining operations, and certainly will comply with all state laws.
Thanks, Mr. Wyman.
Just one additional comment in addition to those from Peter. I would ask that the DRMS take a look at the rationale, which says the L&E process is either under review or in process, something to that effect. I believe it's on page 4. I could be mistaken. As Peter indicated, not only did he call Jeffco County, I've contacted him 3 times since May, asking the question whether they have a permit in-house or an application, in-house. They do not. They've confirmed it 3 times. And the only reason I was asking the question is because the applicant had indicated in the response to the second adequacy review letter that it was their intention, and the inference was it was an immediate intention that they were going to pursue an application with Jeffco. That statement was made in late April. So anyway, I'd like the rationale document not to reflect that an L&E is in process at Jefferson County, because if it is, they're not aware of it. Or if it is, there's confusion on that point. That's all I have to say.
Okay.
And I would emphasize again that, you know, the type of zoning application or the actual interface between the applicant and the zoning department for Jefferson County, those are the issues that I would precisely say are outside the jurisdiction of, you know, the DRMS board. You know, I don't think that we want to get into the mechanics of how we obtain zoning or what zoning is proper and, you know, try to estimate whether or not efforts will be successful. You know, I think at this stage of the game, it is appropriate and adequate for us to say that we will pursue whatever and obtain whatever zoning is necessary to allow us to permit to go forward with mining operations before those operations commence.
Okay. May I ask the question, everybody? My apologies. I had that question on the Ford Delta for Mr. Jeff Fugate. Just as we're in the period of being able to ask questions and get clarity, Ford Delta in 32.5 115.4 says the board or office shall not deny a permit except on one of the more the following grounds. And on 4 it says the proposed mining operation, the reclamation program, or the proposed future use is contrary to the laws or regulations of the state or the United States, including but not limited to all federal, state, and local permits, licenses, and approvals. So what that sounds like, that would be, you have to show it now, not later, and get your permits later in line. If there's something that's flagrant right now, if it's, say, contrary to a law of the United States right now, would that count as a reason that can be denied, according to Ford Delta?
Under that provision, the 114.4D provision, the division's historic interpretation application of that is that it's discretionary, that the act and the implementing regulations afford the applicant operator the opportunity to secure necessary permits from whatever required agency there is in order to move forward with their mining operation. There's no requirement. The language is clear that it's not a shall deny.
Right, may deny.
Requirement. So there is discretion there. And as is the case here, when an applicant indicates that they are in communication and in process to secure the required permits, typically the division will move forward with their review process and allow other agencies, procedures, and requirements to play out. They're not going to deny a permit when there's an opportunity for them to address zoning concerns or to secure a stormwater discharge permit or any of the other permits that may be required before the commencement of a mining operation. So that's the division's interpretation of that 4D subsection.
If that's your historical interpretation, could you provide citations to that historical interpretation? Because your rationale provides literally no citations. And that interpretation literally elides Roman numeral 1 and Roman numeral 2. It says, well, permits and somehow state and federal laws are all the same thing. But you don't provide any basis for that. And that seems contrary to at least 2 Colorado Supreme Court state decisions I've already read. So where have you articulated that?
Again, I think we just have a substantive disagreement here that we're not going to work through today. My citation is, you're welcome to use the division's laserfiche to pull recent permitting activity where this process has played out, where applications indicate required permits that they will secure before the commencement of the operations, but oftentimes they don't have those permits in hand when they apply to DRMS or receive
talking about permits. And we're talking about rezoning. Rezoning is changing laws. Permits are things that are issued when you already have the zoning in place. I want to know where it's okay to ignore state law on the assumption that you're going to get that law changed.
This is a discussion that we will have in front of the board. We are now adjudicating, arguing these particular issues. That is not the purpose of the pre-hearing conference.
Well, you said that they weren't valid.
We understand your position, and we look forward to hearing more from you at the hearing.
Mr. Wyman.
Just one final observation. It wasn't any of the objectors that decided to put this item number 1 within the jurisdiction of the DRMS. So it seems to me it may be a valid discussion topic. And if there's debate on that, well, yeah, let that go forward, but we certainly don't need to debate it here. It seems like
Agreed.
Mr. Middleton disagrees. It seems the DRMS has a position. You guys need to work that out. We just merely said that zoning is still on our front burner in terms of an issue for us, primarily the question of the applicability of the LNE process vis-a-vis the appropriateness of a rezone from A2 agricultural to PD for mining. That's the basis of our issue.
Sure, and
we've been talking to Jeffco about that.
Sure, and Mr. Middleton filled in a question, but the fact remains, this is a category that was put in the rationale as a category of objection. If you feel like this objection hasn't been resolved, then it's going to remain on there, and all parties can go to the board and present their evidence and their witnesses, and the board will make a determination. Okay. So before we move on, I just want to clarify items that the board will hear, and this is going based on the rationale as items 1 or categories 1, 2, 3, 4, 5, 6, 7, with category 8 being identified as resolved. Okay. So moving forward now, we need to establish the board hearing process. What this process is the manner in which the board is going to hear all of this testimony, the issues, the presentations. So generally there are 4 categories here that we're going to do. As far as the applicant and the objectors go, there's basically 3 categories, and there's a reason for that. So the categories are the introduction to the board, the presentation to the board, rebuttal to the board, and then closing to the board. The reason why there's only 3 associated with the objectors and applicant is because the introduction is done by the division. Basically, all that introduction is similar to what Eric Scott presented here today. We're just going to go over the chronology of the application, the permit, throw some maps up there, let everybody recognize what we're talking about and why we're there. That's it. That's all we do on the introduction. So in terms of timing, I imagine it'll be similar, but what amount of time does the division anticipate needing for introduction?
10 minutes.
So 10 minutes for introduction for the division. Following the introduction, we're going to move into presentation. Now, presentation is where you're going to basically present your case. Why this, in the objector's case, this application shouldn't be approved. The division's going to state what rationale they have under the act and the rules to approve it. The applicant's going to describe their process and for the board to hear. So generally how we do it in terms of order on presentation is the division will go first, followed by the applicant, and then concluding with the objectors. So that said, under presentation, how much time does the division feel is appropriate for their presentation?
1 hour.
So 60 minutes for the division. Mr. Middleton, for the applicant, what's the appropriate time for you to make your presentation to the board?
I think we'd like to be sort of on par with all the other participants. So I would ask for an hour.
Okay. And for the objectors, now this is going to be a little difficult as the objectors, unless there's some sort, and this is my recommendation to the objectors, unless there's some sort of consolidation of discussion on these items, if you have the same objections, and I heard a few folks speak up for the same objection. So if you have the same objection, I think it'd be best to consolidate as best you can. If you feel like you can't, then we can figure out a time period for each individual to speak, those kind of things, but we want to maintain a concise agenda on this. So that being said, if anyone wants to speak up on the objectors in terms of a time frame for your presentation.
May I speak?
Sure.
As Protect the Hogback, we are a nonprofit. We do have about 350 or so advocates. We have done a lot of work and research. We would like to ask for 1 hour. We will try to coordinate with other neighbors so we do not have multiple iterations of the same argument. But we have very specific arguments and expert witnesses, and we're not going to waste your time.
Can I hear from some other objectors?
I concur with Mr. Rollick.
In that you want an hour, or you will consolidate with Mr. Rollick?
I am also with Protect the Hogback organization, and so I will concur with what he has just given you.
Perfect. Okay. Thank you.
I am also here to support them.
Okay.
Yeah, and
thank you.
I'm also here to support them.
Thank you.
Also here to support them.
Thank you. Anyone outside of Protect the Hogback that is requesting some time to speak, or if they want to consolidate their time with Protect the Hogback group?
I am not part of Protect the Hogback.
Okay.
I want time to speak independently of them, though I do support what they're doing. I suppose if it's not too onerous on everyone, I'd request an hour, though I may cede much of that time. It's just a little hard to predict because I will do everything I can not to reiterate arguments, but to provide my own independent views.
I support Peter because he has a different legal approach than all of us, and everything that we've talked about will not overlap.
I concur.
Mr. Waitman.
I'm looking at my screen and not seeing one of the objectors that was on the call earlier. It's Mr. Ian Wilson. He is not affiliated with Protect the Hogback. And again, I don't know that I can speak for him, but he had indicated to me that he intended to speak to hydrology as a topic. I don't know exactly what that would entail, but I'd hate to see him lose an opportunity to say something, although I see he's dropped off the call apparently. So anyway, that's just, I don't know how you handle that. He may need 5 to 10. I don't know. It's my understanding that he may have submitted some exhibits that he was prepared to speak to.
Jerry, he's floating on the chat. He says he needs 20 minutes on the chat. Sorry to interrupt.
Oh, he is there. Okay, he's just not showing up on my screen. Okay, right, sorry. Thank you for that. Beyond that, I would just say and agree with both Mr. O'Brien and Mr. Rollick, who indicated that we will make every effort to keep our comments focused and presented within an hour. That's probably not going to be easy, but we understand and respect the time and appreciate the opportunity.
Agreed.
Anyone else on the call outside of what was already been said?
Can I ask an objector a question?
Sure.
There's a Mr., I think it's Mr. Wheeler. He's one of our, what I would call advocates. We've had some dialogue, maybe not direct, but probably email. And I was under the impression that, and I hate to put Mr. or Mrs. Wheeler on the spot, but I'm under the impression that they had a point of view relative to some concerns, as perhaps a couple others on the call. So kind of a general question or request, if anybody is hoping to say something at the hearing, this would be a perfect time to bring that to the DRMS staff attention. If not, we move on.
Okay, so let me tell you where we are right now. And this is just through our first section here. We got the presentation in order of the division, the applicant, and the objectors in that order. The division's asking for 60 minutes. The applicant's asking for 60 minutes. And from what I understand, the objectors are asking for, from what I have, 2 hours and 20 minutes. Is that correct? Yes?
There's Kim Wheeler.
Ms. Wheeler, you going to say something?
Ms. Wheeler, you need to unmute.
Hey, stay. No barking.
Yeah,
I'm sorry. There was a delay on my end.
Sure.
Thanks, Mr. Wyman, for including us. But I will make sure all our comments are given through Protect the Hogback because we have been supporters of that. So, oh, I thought I was.
You're good. We can hear you.
Can you not hear me?
No, we heard you. Thank you.
There was a delay on my end. Thanks, Mr. Wyman, for including us. But I will make sure all our comments are given through Protect the Hogback because we have been supporters of that. So,
Okay. So do I have those times right? 2 hours and 20 minutes on the objector side? Is that what everybody else has? Okay.
Yep.
So now we'll move on to rebuttal. And generally, previously, how we've done the order on rebuttal is the division will start rebuttal, followed by the objectors, with the applicant, as it's their burden, finishing up. Does anyone have an issue with that order?
Just for clarification, I'm sorry, I missed the first part of that. What is the sequence? Is it division, objector,
division,
applicant?
Objectors, applicant
Okay.
on rebuttal?
Okay, sorry, thank you.
You're fine. So on rebuttal, division, how much time do you need for a rebuttal?
30 minutes.
30 minutes for the division. The objectors?
Hard to say. Depends on what's the rebuttal.
PTH can do it in 20 to 30 minutes, I think. Correct me if I'm
30?
wrong, guys.
Okay.
So be it.
But that's not all. That's not all objectors, though. That's just
Sure.
I'd also request 30 minutes.
Okay. Anyone else on the objector side for rebuttal? Okay. And Mr. Middleton, for the applicant, how much time do you believe you'll need for rebuttal?
I think 30 minutes is fine.
Oh, I like all these perfect numbers.
Can I ask a clarification question? Peter, forgive me, your last name. You requested 30 minutes for rebuttal. Were you also requesting time for presentation as well?
Yeah, 20 or 60 minutes.
60 minutes, okay.
Yeah. Okay, so what I have on rebuttal, I'm sorry, Mr. Middleton, what was your time frame on rebuttal?
30 minutes.
Perfect. Okay, so what I have on rebuttal is the division, 30 minutes, followed by the objectors with 1 hour, followed by the applicant with 30 minutes. Okay, now moving on to closing. This is just what it says. This is just your closing argument. We generally follow the same order as rebuttal. So that's the division starting, followed by the objectors, and then closing with the applicant. So if there's no issues with the order, how much time does the division need for closing?
5 minutes.
5 minutes for the division. For closing, the applicants, the objectors for closing.
Peter, you want to go first?
I don't need any more than 10 minutes.
Okay. Others for the objectors on closing?
It's difficult to say, but I'm going to guesstimate probably about 15 minutes for us.
Okay.
Thanks, Bill.
Any others for the objectors on closing?
Whoa.
Okay. Oh, go ahead.
I'm sorry to ask this question, but my understanding, for the most part, we're talking about these time slots for party status individuals.
Right.
Correct me if I'm wrong, but even if somebody does not have party status, but participates in the hearing as an interested party, how do you manage their potential time slots, and what would those time slots be? Just
Sure.
That's my question. We haven't addressed that.
Yeah, Chuck Koyman can answer that, attorney for the board. There is a time slot for public comment, Chuck.
Yeah, and that usually comes after, because of the statutory process for these applications and the objector, the statutory timeframes for submitting objections and obtaining and maintaining party status. We limit the presentation to, those who are who have party status. Afterwards, after the board has made its decision, there is always room for public comment at the meeting, but that's generally how this works out. So we're not scheduling public comment because this is a hearing subject to judicial review being held and open to parties.
Well, just on that same point, I thought I had read that individuals, regardless of party status, still have an opportunity to participate in the hearing. What I just think I heard you say is not necessarily.
Correct.
So
yeah, they have an opportunity under kind of board's practice to allow for public comment, but because any decision of the board following the hearing is going to be subject to judicial review, and that review is limited to the record made during this hearing.
Yeah.
We tend to keep the presentations during the hearing that's making the record to those with party status and their witnesses. So if you know a member of the public who you want to afford some of your time as a witness, make sure that they're on your witness list, and they're kind of whatever they're going to say furthers your testimony.
I'm not asking for us or me or members on this call. I'm asking just a general question. If somebody wishes to comment, weigh in, have a point of view, who's not a party, do they have that opportunity? And it's kind of vague.
Not during the
whatever.
Hearing. Yeah, because of the way that the statute provides and the review that follows afterwards, we don't have open mic time during a closed hearing. Similar to you wouldn't at a court, not anybody gets to get up and say whatever the heck they want during a court proceeding.
Yeah, I'm not challenging you. It's not how I understood it as I've read it, but that's fine. Let's move on.
Okay, so we have for closing for the objectors, we have 25 minutes. Currently, we have 5 minutes for the division, 25 minutes for the objectors. Is that correct? Anyone else on the objector side?
Just to clarify, we had requested, Protect the Hubback had requested 15 minutes for the.
Right, Sure. I have 15. So we have 15 for Protect the Hogback. And Peter, you had 15 for you, correct?
10.
Oh, 10. That's where it is. So yeah. So we have 25 total right now.
Okay, thank you.
Yep.
You need the applicant.
Yeah, I'll do the applicant. So is that it for the objectors on closing time? Okay. And then Mr. Middleton, for the applicant, how much time do you need for closing?
I think 10 is sufficient.
All right. All right, let's see what we got here.
While he's doing that math, this is Ben Teschner from the State Land Board. I'm wondering what the appropriate moment would be. We as the landowner would like to speak very briefly in support of the application. And I don't need any rebuttal time or anything like that, but happy to speak for 5 minutes. No slides or exhibits.
I've been, I can clarify that for you. We will call you as a witness on behalf of the applicant and anticipate that you'll talk for a few minutes and, summarize your support and your position.
Great, thank you.
Perfect, thank you. So right now we're at 7 hours, a little over. Is that what you guys have?
7 hours, 10 minutes.
So what do you think?
What is the meeting?
Say again?
Just a question. What is the July 20 meeting, assumed meeting duration as published?
Well, that's what we're trying to figure out. This is pretty much the only item, right? With the exception of course, record keeping kind of things. We do division reports, any ongoing consent items, those kind of things. So we also eat lunch. That's a thing. And we take some breaks. So the board hearing starts at 9 in the morning. And right now with just this item, it's 7 hours. So you add in, all those ancillary issues that we're going to have to deal with. So you can do the math. It's a long day. If we stick with the 7 hours.
Could be 2.
Could be 2.
Could be 2 days.
Yeah, could be 2 days. So so in terms of time, I just want to make it clear, and I appreciate everybody's time. Like I said, I appreciate and I hope that there is definitely some consolidation. And I do want to remind the objectors and really everyone that the board is sensitive to duplicative kind of testimony. So as much as you can avoid that, as much as you can avoid the non-jurisdictional issues, bringing those to pass, and you just stick to the 7 categories that we've agreed on here today, it would be highly appreciated by the board. I can promise.
I would also clarify that the board tends to ask questions. I mean, obviously they don't have to, but it's pretty common for the board members to ask questions during presentations or kind of at the close of presentations. We do not count that against your presentation time. I run the timer for the board and I stop it when they're asking questions and you're answering their questions. So that kind of cuts both ways in that it means that we've got 7 hours here, but everyone needs to understand that that's just what we have on paper. It's going to take longer than that because the board will be asking questions. And, kind of the flip side of that is that may play into your kind of calculus as to how much time you actually need. If you're already, if kind of baked into your time is you're already anticipating board questions, then there might be room for you to whittle some of that down, understanding that board's questions are not going to count against your presentation time. So, you know, just one more thing to consider as we're sort of looking at the time frame this is gonna take, and sort of how the day is going to play out.
Can I ask a question?
Sure.
You know, it's in the DRMS vision in which they state protection of the public. So therefore, is that within the jurisdiction as you spelled out earlier?
It's in 102, 34, 32.5, 102. I think that's what he's referring. Is it general?
Is protection of the public within the jurisdiction of the Department or Division of Reclamation, Mining, and Safety?
Again, this is Jeff Fugate, as an open-ended concept, yes, but there's still jurisdictional boundaries and limits to authority within protection of the public. Without getting into too many hypotheticals, obviously, you know, mine-related protection, reclamation-related protection is within the division's jurisdiction. There's also Mine Safety Health Administration, that deals with issues that are outside of DRMS jurisdiction. So there's many layers within that kind of general protection of public health and safety idea. So I know that's kind of a non-answer, but it's.
I'm afraid so, sir. That's a non-answer. Can you be a little more specific to help me understand? Does the DRMS board care about public safety?
Yes.
All right.
But they are still limited by their authority. So if you have a public safety concern about traffic, that's non-jurisdictional to DRMS.
No, I care about blasting and anybody who might be within close proximity of a blasting operation, sir.
Sure. Yes, that's one of our items.
Yeah, blasting is within the board's jurisdiction, and that's been included in this hearing process.
Okay. And the impact on public safety with regard to those blasting operations is certainly one of our concerns.
Absolutely. That's categorized as number 4 on our list that the board will hear.
Thank you, sir.
But okay, so knowing what, following up on what Chuck said, mentioned about the time, we're at 7 hours. I'm going to throw it out there. You can tell me to pound sand if you want, but is anybody willing to yield time? This is a 7-hour hearing. I see you shaking your head, but it's going to be a long day. Okay.
Jason, can you go back over just the presentation time allotments?
Presentation, sure.
My notes down.
Sure, the question for presentation time. So we have, the order is the division with 60 minutes, the applicant following the division with 60 minutes, and the objectors with a total of 140 minutes. So 2 hours and 20 minutes for the objectors.
In your pre-hearing order, will you break out the various groups, or is it just going to be a time?
I have basically 2 groups. I have, for the objectors, I have 60 minutes for the protection of the hogback, 60 minutes for, I'm sorry, Peter, I don't know your, can't pronounce your last name, and I'm not going to try. So 60 minutes for Peter. And then I have 20 minutes for, at the request of Mr. Wayman.
Oh, that was Ian Wilson, I believe.
Ian Wilson, I'm sorry, Ian Wilson. Yeah.
But Mr. Wayman, did you also request separate 60 minutes for yourself?
No. My comments will be within the PTH 60 minutes.
Yeah. Yeah.
And
so
I will see if I'm brief. You know, I'll be very brief.
So an hour and 40. I mean, 140 minutes.
Okay. Thank you.
Yeah. Okay. Are we good with that time? Anybody has any issues with the time? Russ, what do you think?
We'll present it to the board.
Oh, yeah. So just so everybody's clear, and I mentioned it at the beginning, this is a draft order. Okay, so it's not up to me as the pre-hearing conference officer to give this to the board and they run with it. It's for them to adopt it or not adopt it, or revise it as they see fit. That said, remember that if the board gets the pre-hearing order, the draft pre-hearing order, and they do not agree with the time, if something looks a little different, a little off to them, for example, You got 60 minutes, and then an hour and 40 minutes. If they are like, why is somebody getting an hour and 40 and the other ones are getting 60? They might decide at the hearing to reduce that time. So be aware that that could happen. And that's the reason why I'm kind of adamant about, if you guys have any time that you want to see, then now's the time to do it. You don't want to do it in front of the board. So, so just throwing that out there, just so you know that that's always a possibility, whether they do it or not.
Are you going to be able to publish this schedule for all of us, sir?
So this, as I mentioned before, this pre-hearing conference draft order will go out. I'm going to try to get it out relatively quickly following this pre-hearing conference. I'm going to try to get it out, close of business to all parties by July 12th. That's my goal. It likely will go out sooner, but that's my personal deadline for myself. So yeah, you'll have a copy of it. It'll, like I said, it'll itemize all of the issues that we talked about. It'll talk about the process, the order, the timeframes that we've agreed on here today, and that's what the boards will get. They'll look it over, and then at the hearing, if they have questions, they'll run from there on the order.
Yeah, I was just going to say, if, you know, kind of in the interim between today and the hearing, as the objectors are putting their presentation together and kind of running through that, if you find that you don't need as much time, as we've said multiple times, this is a draft order that goes to the board for presentation. If on the day of the hearing, you know, you've whittled it down 20, 30 minutes or whatever that may be, feel free to raise that with the board at that point in time. You know, and likewise, any other objections or requested modifications to the pre-hearing order, there'll be a time for those to be presented to the board when they consider the pre-hearing order and you know, vote on it. You know, so as Jason was saying, they've got discretion to amend the order as they see fit. And that can be based on their own discretion, or you know, comments or requests, or, you know, objections from the parties. So
okay. All right, so after the process and the order and the times, we have a total time of 7 hours and 10 minutes. Sound right? Whoever else did it, okay. The matter will be set before the hearing of the Mineland Reclamation Board on July 20th, beginning at 9 a.m. As mentioned, I'm going to make every attempt to get the draft pre-hearing order out to all parties by close of business on July 12th or sooner. And just as a reminder, if you are identified as a party and you want to maintain party status, you'll need to be present at the board hearing on by Zoom. It's on the Zoom, or is it in person? Yeah, on the Zoom call. Mr. Wayman?
Just a housekeeping question. I see in the chat, there's a series of questions in the chat. Some of them are about a format for sending in exhibits. Others are about the size of the file. And I'm just wondering, is anybody responding to those?
I tried to respond to Ian because Camille helped me for hours yesterday. And I wrote Ian an email trying to help with that so we don't bog down the meeting. Ian can call me anytime because Camille was very easy to work with and she guided me through the whole process. That's all I want to say.
And just to reiterate, files that are sent in for any of your materials should be in a PDF format and provided directly to Cami. We're not accepting files through file transfer services or anything like that.
I'll protect the hogback. Exhibits, witness lists are all submitted.
Okay, very good. Thank you.
Okay.
One more quick clarification. So with regard to our presentation, that is to be in a PDF format, sir?
PowerPoint. Yeah, except for the PowerPoint, right? If you have a PowerPoint.
Yes, it'll be PowerPoint.
We will.
That's fine. Yep.
Okay. Real quick, everybody. Camille did say that she accepted JPEGs and PNGs and loaded them up yesterday via Dropbox transfer service. Is that going to cause a problem now? Because it was approved and she uploaded everything.
It's fine.
Are we okay?
If everything's uploaded, there hasn't been a problem. So
okay, perfect.
Yeah.
No, because she ran into a problem with some specific Canon camera files. We worked that out. She worked late. Very cool. Much respect. Just want to make sure that we were okay. And
yeah,
she
absolutely.
said that PowerPoint, and I talked to Michael Cunningham. Is it agreed that PowerPoints are due by next Friday? Because I guess there was a before the board packet goes through. Is that about right, guys?
Yeah, I think on the PowerPoint, just a couple of things to note for the group. You will be running your own PowerPoint during your portion of the presentation. So just have that ready to go. We're not going to load it up. You'll have to do the screen share function and then just walk through that PowerPoint as appropriate. I think if all parties agree today, we could simply do an exchange of those PowerPoints at the conclusion of the hearing for the public record. That'll afford folks more time to develop those materials prior to the hearing.
I think that's fine. My only concern would be that we don't include in the PowerPoint materials any, exhibits or anything of that sort that was not included in the original exhibit lists, or don't rely on materials that were not submitted to all the parties prior.
Yeah, that's fair. And I think we've that's a line we've drawn in the past is that your PowerPoint presentation isn't part of, it's not part of the record until you present it to the board. But everything in it, pictures, exhibits, or anything should be, out of fairness, something that was on your exhibit list and already provided to the other parties in advance.
Right. It's emphasis of what's already there and not the presentation of new material.
Right.
I'm sorry, I need clarification on that. With regard to new material, are we talking about written material or are we talking about spoken material?
I don't want to parse it too much, but I think what we're looking for, kind of a line we're drawing is like, if you just have a bullet point of, hey, here's the points we're making in relation to this photograph or this exhibit, and there's a map or, some kind of chart that your hydrologist or whoever put together, the bullet point is not an issue, but if whatever chart or exhibit or photo that you're referring to, in fairness, should have been part of your exhibits that you filed today, right? So the idea is that we're not having, we don't have trial by ambush, we don't have a hearing by ambush, and so everybody knows going into the hearing what the exhibits of all the parties are, so that we can have a fair presentation to convey information to the board, who's the decision maker here. Does that make sense?
Yeah, that was explained to us by Camille as well. We did spend about a week compiling everything that we will present as far as information or source material. Everyone already has via Camille's files. Bullet points, like you said, or we say, hey, now look at the line number 3. That's fair game. Everything that we did, we compiled. I don't want to do any more research anyway. So it's all there. Trust us. Great. It's all there.
Thank you.
Mr. Wayman, do you have something?
Yeah, all I was going to add is that, at the risk of a data dump or an overload, we may have said a couple things that we ultimately don't end up referencing, but out of caution, we've had multiple meetings. We've attempted to supply everything exhibits that we are likely to reference during our presentation. We respect the time of the MLRB as well as the DRMS staff and all the applicant and all the stakeholders involved. So, it's not the first meeting we participated in. So we're going to do our best to play by the rules. Just want to reassure you of that.
Thanks. Okay, if there's nothing else, we can probably conclude. If you have any questions, reach out. Like I said, this draft order should be going out relatively soon. Everybody can look at it, and you have concerns, file motions, object, those kind of things. And we'll see you next week, I guess.
2 weeks.
2 weeks.
I'm sorry, 2 weeks. Jeez. Yeah,
Okay.
2 weeks. We'll see you next week. Yeah. Okay. Thank you, everybody, for participating. Super important. Appreciate it.
Thank you.
Can you print out that? Can you? There's a link where you can download the chat. Like if you open the chat, or it might be